Assalamualaikum and good day. My name is Nasrin Nabihah Binti Zuperi and my metric number is 272244. And this will be my video presentation prepared for assignment 2 of the Civil Procedure 1. So the topic that I have chosen to discuss is chapter 13 of the syllabus, which is regarding the amendment of writ or pleadings and also the amendment of judgment or orders. So before I further studied this topic, a few questions arose after we learned about pleadings and writ during our civil procedure classes. So what happens if the pleading needs to be amended after it is found that there are a few mistakes in the details? So to begin with, let's start with the introduction part. So in the rules of court, it allows parties to amend, but subject to the rules, their originating process, pleading, and etc. in the action. But in general, the court may at any stage of the proceedings allow either party to alter or amend their pleadings in such manner and on such terms as to causes or otherwise as may be just. However, it must be understood that amendment is a feature of rules of court to cure any irregularities or omission. When it comes to amendment, the court often takes a holistic approach within the framework of the rules of court to determine just outcomes. So, if we refer to the Rules of Court 2012, it can be derived that there are two types of amendment, which are amendment with leave and amendment without leave. So referring to Order 20, Rule 5, Paragraph 1, it mentions that parties have right to amend writ or pleadings at any stage with the leave of court. However, there are matters that need to be bear in mind that there are three matters that can be amended with the leave of court, and this can be seen in Paragraph 3, 4, and Paragraph 5. So the three matters are an amendment to correct the name of party due to mistake, but the mistake must be genuine and not misleading. Second, an amendment to alter the capacity in which a party sues. And lastly, amendment may be allowed to add or substitute a new cause of action if the cause of action provided that it arises out of the same facts. Nevertheless, there are also few circumstances where the court may refuse the application of amendment. First, if the effect to the amendment will introduce a totally different, new or inconsistent case, which can be seen in the case of Chin Kok Kwong Construction against Sunrise Towers, where the court stated that it will not allow an amendment if it would turn a suit of one character into a suit of another and inconsistent character. Second, it will cause injustice to the opposite party, which can be seen in the case of the Benoi 4 Sindo Timber Enterprise against Benoi 4 owners and others, where the plaintiff made application to amend the statement of claim to include new and further particulars of negligence, but the defendant objected as it will cause grave injustice. But the court's duty is to weigh which party will suffer graver injustice, and it turns out to be the defendant. Therefore, amendments were denied. Lastly, it was barred by time limit at the date of the application, which can be seen in the case of Credit Corporation against Fong Tak Sin, where the application to add or substitute a new party after the expiry of time limit should not be allowed, but the court has discretion in three situations where amendment is allowed in situations under Order 20, Rule 5. But what will happen if the amendment is not done within the time period? Order 20, Rule 9, where the court makes an order giving any party leave to amend to a writ, pleading, or other document, failure to do so within the time period shall result the order cease to have any effect. Moving on to the second type of amendment, which is amendment without leave. So it has been stated in Order 20, Rule 1 that plaintiff may, without the leave of court, amend the writ once at any time before the pleading in the action began. However, it is also important to read this with Rule 3, where it mentions a party may, without the leave of court, amend his pleading at any time before the pleadings are deemed to be closed. Where he does so, he shall serve the amended pleading on the opposite party. So the last part of this video would be the amendment of judgment or order. So can a judgment or order be amended? Yes, certainly. If we look into Order 20, Rule 11, it explains that clerical mistakes in judgment or orders or errors arising therein from any accidental slip or omission may at any time be corrected by the court by a notice of application without an appeal. So in relation to this, it is relevant to mention that the court has no power to amend or alter a judgment or order which has been passed. But there are exceptions to this rule. First, court may amend or alter the order which has become null due to the failure to comply with an essential legal provision, such as the service of process that can be set aside by the court which made the order. In the case of Tay E. K. Seng and Tay Cho Ko, where the respondent obtained order under the Companies Act for the directors to call the 14 and 15 meeting within the prescribed period, but the said order could not be served, and the respondent applied to court for the order to be varied and to provide the meetings to be called by the company. Learned judge trial allowed the application in this case. In another case is the case of the estate of MB bin Haji Abdullah deceased, Muhammad bin Haji Omar, against Zainab binti Muhammad Sheikh, where the court stated that it had no powers to amend or alter a judgment or order which has been duly passed and entered, except where there has been an accidental slip in the pleading, or where the judgment or order does not express the manifest intention of the court. And with that, it marks the end of this video presentation. So that's all from me. Thank you.